Hello?
Hello, everyone. Can you hear me? It looks like we still have a few
Yes.
connecting to the audio, so we'll just give them a few more seconds and then we can go ahead and get started. For those of you that are here, hello, I'm Sheridan Hughes. I am your new program administrator. Some of you, I'm sure, have received an email or two from me by now, but I just took over Emily Young's position. So she is still with the bar and still totally accessible if you ever need anything, but I am also here and I'm your new liaison. So if you have any questions or need anything at all, please feel free to email or call me anytime.
All right, everyone, thank you for joining us in what hopefully will be one of our last virtual meetings. I want to start this meeting off by acknowledging the passing of two titans of our practice, and Toby Brigham and Stumpy Harris, two men that I have personal fond memories of, and I know many people here have fond memories. And so if we could start this meeting with a moment of silence to reflect on the careers and lives of two great men, not only in the eminent domain world, but just in the state of Florida in general. So we're going to start with a moment of silence before we proceed. Thank you. So this morning we have presentations from Brian Smith and Ryan Reese. But prior to that, and Sheridan, you can help me with this. One of the things, we get a lot of requests for people running for bar positions. And so we've had a request for 5 minutes for someone to make a presentation that, Sheridan, if you can allow them to do that. Are they on here?
Let's see. So is Scott Westheimer on? I don't see him yet. And our other candidate will be Lorna Burton Brown, or Brown Burton, I'm sorry. And they are both members of the Board of Governors. They are amazing. I will email both of them and just make sure they have our link.
So Emily, maybe then what we can do is allow them some time on the back end. That way we can respect our speakers and everyone else's time. Without further ado, I'll introduce Brian Smith of Sheffield, Lowndes in Orlando. No?
Lowndes.
I'm sorry, Lowndes Drozdick. I'm sorry. Lowndes, I apologize. So of Lowndes in Orlando. Most of you, if you've been around, have been in contact, have met Brian. His reputation speaks for itself. So I'm going to turn it over to Brian and let you tell us about special benefits.
Thanks, Blake. And Logan, I'm definitely not trying to tread into your territory there over at Sheffield. Welcome everybody, and thank you so much for joining us. When I agreed to present on, well, at this meeting and on this topic, I actually thought we were going to be in person. So I'm disappointed that we're here on Zoom. I wish we could all be together, but hopefully for the next meeting, we will have that opportunity to be meeting in person and actually have some time to interact with each other. I'm going to share my screen and let's just see if this works here. Where did it go?
The magic is happening.
What's that?
The magic is happening.
I know, here
This
it
is all magic.
At least I'm not presenting on the use of technology in. Where is the share? Somebody just pop in and tell me, because
Brian, if you look at the bottom of the screen, you might have to actually scroll down there for it to pop up.
Yep.
Perfect.
Well, let's see if that works. Boy, that is a fail. Hey, Sheridan.
Yes, would you like for me to share for you?
Sure.
Okay. 1 second.
Fine. Fine. Here, look at this man. Look at that man. You're gonna get some CLE credit.
There we go. And if Sheridan, if you don't mind just hitting the, there we go. And then hit slideshow.
All right.
Great. Okay, so my topic today is special benefits in eminent domain valuation specifically. And Sheridan, I don't know, am I able to click through it, or do you have to do that for me?
I believe I have to, so you can just tell me when you'd like to.
All right, this is awful. I'm sorry, everybody. All right, next, and then click to the next one. And now the next slide, we all know, one more click, what we're yelling about. Now we're yelling about technology, and I apologize again for that. But special benefits does seem to be kind of a hotly contested topic in eminent domain valuation. There's a lot of differing viewpoints on it. It's confusing. There is not a ton of case law on it. And so what I'm going to do is kind of take us through kind of a primer on special benefits. And Sheridan, if you'll just go to the next slide and click through. So, and then one more. Benefits or enhancement is what we're talking about today. And we're going to parse that out a little more as we go through the presentation. But everybody knows what full compensation is in Florida in eminent domain. We all are familiar with kind of the four basics, and there's others, but these are kind of the four keystones. It's the value of the part taken, the improvements in the part taken, severance damages to the remainder, and the partial cost to cure the remainder property. So when we talk about an offset or benefits or enhancement, what are we talking about there, and what are we offsetting? We'll get to it in a second, but a preview, we're offsetting severance damages. We're going to talk about general benefit versus special benefit, an important distinction that comes into play, and then we'll drive into some examples and some hypotheticals. And Sheridan, if you just click through to the next slide. Yep. So first of all is the concept of a benefit. The benefit concept at common law has actually no history. I can't take a deep dive as many academics would like into Blackstone and try and find, well, where do we see this in the common law? There's not a history of using benefits or offset in the common law. But what I can do, and click to the next slide, Sheridan, is I can talk a little bit about eminent domain just generally. And if you remember back to law school, your property class, eminent domain is not a power that the Constitution gives to the state. Eminent domain is one of those powers that is only limited by a Constitution. In other words, up until the drafting of the U.S. Constitution, and I believe there was some reference to it in the Magna Carta as well, but in those documents, it's just presumed that the state has the authority and the power to take private property. And so the constitutional limitation on eminent domain is what is important. So Spafford spelled that out, that it's an attribute of the sovereignty which the state would have even though there were no constitutional grant of the power. In other words, the Constitution did not have to grant it to the state already had it. It can be limited by the Constitution, but it's not created by the law. And Sheridan, if you'd flip to the next slide for me. So we have Florida's, and there's a couple more bullets. Yep. We have Florida's Constitution from 1885. And in that version of the Florida Constitution, Section 12 contained in the Declaration of Rights said, "Nor shall private property be taken without just compensation." Further down in the Constitution, Article 16, Section 29 had this provision: No private property nor right-of-way shall be apportioned to the use of any corporation or individual until full compensation, therefore, shall first be made to the owner or secured to him by deposit of money, which compensation, irrespective of any benefit from any improvement proposed by such corporation or individual, shall be ascertained by a jury of 12 men in a court of competent jurisdiction, as shall be prescribed by law. So in the 1885 Constitution, there was a provision governing eminent domain in some form that said you may not consider the benefit of the improvement that's either proposed or constructed by the corporation or individual. And Sheridan, if you'll click to the next one there for us. The old Florida statutes, pre-revision in 1957, the eminent domain statute 73.10 talked about the judge causing to be impaneled a jury of 12 men to try what compensation shall be made to the defendants for the property sought to be appropriated, which amount shall be a just compensation, therefore, of condemnation or appropriation, irrespective of any benefit from any improvement proposed by petitioner. So now you've got the constitutional restriction on consideration of a benefit. You have a statutory restriction on consideration of a benefit. But the statute changed. And Sheridan, click for me. The statute changed and deleted that provision of irrespective of any benefit from any improvement proposed by petitioner. It replaced it with language that's very similar to what we see in modern day 73.071. And that language is there on the screen for you. I'll read it because I think it's helpful to hear. It changed it to say when the suit is by the state road department, county, municipality, board, district, or other public body for the condemnation of a road right-of-way, the enhancement, if any, in value of the remaining adjoining property of the defendant property owner by reason of the construction or improvement made or contemplated shall be offset against the damage, if any, resulting to such remaining adjoining property. In 1963, the statute changed again. It was expanded. It specified the Department of Transportation, but it also says now that it is for the condemnation of a road and added canal, levee, or water control facility right-of-way. That statutory change, obviously a little less important than the previous one, but the new wording of the statute created what appeared to be a conflict with the Florida Constitution. Remember, Article 16, Section 29 said irrespective of any benefit, and now we have a statute that says the enhancement shall be offset against the damage. And so along comes the Daniels case. And I've sent obviously this presentation to Sheridan because she's running through it for me, but she has a copy of it. If you guys want these references, you can get a copy of the presentation later, but I've got them in here. But the question the Daniels case asked was, how did these two interact? Is 73.10 unconstitutional because of this conflict? And Sheridan, if you'll click for us. Thank you. And the Supreme Court considered it, but what they did was they looked at Section 29 and said, well, this actually spells out what is compensation taken or for property taken by private corporations and individuals. In those circumstances, no offset is permitted. But because we have Article 12 earlier in the Declaration of Rights, this is the more general eminent domain provision that governs state actors, governmental actors. And this is the one that is all encompassing for those entities. So the statute permitting consideration of a benefit passed constitutional muster in the Daniels case. The Daniels case also asked two important questions that I just kind of geek out on a little bit. The first was, was the statute impermissible because it was the legislature telling the judiciary how they are to do their job. So if Spafford says that valuation is a province of the jury and not the legislative branch, is it a problem that the statute says you consider the offset, or you consider the enhancement to the property and you offset it against severance damages? And the court said that because this was a legislative declaration of just compensation that accords or agrees with the judicial view of the matter, historically, this is in line with what we would do. We would see the legislature kind of helping to frame how we come up with the compensation, that it was an okay thing. It was not a problem for this court. It also said that the legislature can't direct anything less than just compensation be paid, but it can require more. I thought that was an interesting tidbit. But the second thing that Daniels did was Daniels dove deep into a bunch of secondary sources and tried to delineate or create a rule for which enhancements are allowed when they're being considered by the court in valuation trials. And the distinction that Daniels made was special benefits versus general benefits. And it was the rule that Daniels set forth that said only special benefits will be permissible, those accruing specifically to the parcel, not in common with the rest of the public. So impacts that the project has that raise the value of all properties on the project are not permissible, they are not admissible, but those benefits which are specific to the property and not general to the neighborhood are allowed. The quote was, evidence thereof would not be admissible without proof that the increase in value, and this is the important language, resulted directly and peculiarly to the landowner's remaining land as a result of the improvement. Now, the Constitution was amended again in 1968, revised in 1968. And just a recap, 1885, we had the two sections, Section 12, general, Section 29 of Article 16 was right on with the corporations and individuals taking property. The 1968 Constitution combined it all. And there is one provision in today's Constitution that deals with eminent domain, and it's this one. Article 10, 6A, and that's the no private property shall be taken except for a public purpose and with full compensation therefore paid. There hasn't been a proclamation or a statement by the court yet on this point of whether the statute with special benefits is actually a problem under the current Constitution. And I talked to a number of my friends in the bar, and they said, Brian, you don't need to worry about this. It's not going to happen. But I thought it was an interesting point that perhaps there is an issue with full compensation and this particular statute permitting consideration of an enhancement. I want to divert to a case that happened in Orange County. It was handled by a number of friends over at Gray Robinson on behalf of the property owners. The Buckman case. And the Buckman case was a partial taking from some property owners in Orange County for the realignment of Clarkona-Ocoee Road. And so the next slide will show you an aerial of a kind of pre-take, and I wish I had my control of the mouse, but you can see the small road east-west that dead ends when you get to the west side of the property. So that green forested area, north and south of that road was the property. And if you go to the next slide, Sheridan, you'll see the after. So you can see they realigned Clarkona-Ocoee Road. And that road that used to go north-south is now a cul-de-sac. And Sheridan, if you'll flip back one time, just so everybody can see it once more, that's what it looked like. And then that is what it is presently, or was caused by the eminent domain action. So the Buckman case went to trial. the owners got a verdict of $2,035,279 in severance damages, and the county appealed. They appealed on the grounds that there was an error in the jury instruction, and the 5th DCA agreed and sent it back for a trial just on severance damages. The second trial happens, and the county now presents evidence that the property was actually benefited by the road realignment. And they use that benefit to reduce severance damages, offset them. Importantly, they did not bring special benefits into the case in the first trial. That was a novel tactic for the second trial. But at the second trial, the evidence for valuation was presented, as you can see on the screen there. The owner presented nearly $4 million in severance damages. The county presented nearly $2 million in special benefit. And the jury returned a verdict of $269,716. The issue here, as you can see below, was there was an interrogatory verdict form used. It included blanks for the jury to spell out exactly how they arrived at their verdict. And so you see that the jury found a little over $3 million in severance damages, but they also found nearly $3 million in special benefits. That's how they got to their net verdict. Sharon, if you'll click for me there. So the problem here is the special benefit testimony ranged anywhere from 0, which the owners obviously put on, to almost $2 million that the county put on. The verdict form gave the jury the ability and required them to provide specificity as to what they concluded to as to the special benefit set off. And they concluded to something that was well above the range that was presented at trial. And so the owners objected. The court asked for motions to be filed, and the owners' judgment notwithstanding a verdict motion sought to strike the special benefit verdict in its entirety as being, outside the range and thus not supported by the evidence, or do an additor and reduce the amount of special benefit offset to the maximum amount that was in evidence of $1.979 million. The court said, okay, we can do the additor, and that special benefit set-off number can be corrected at the discretion of the court. Or if the county prefers, we can retry the case. And so the county chose to do neither and elected to appeal. And on appeal, the 5th DCA said that the owners were right, that the purpose of the interrogatory verdict form was to demonstrate the correctness of the verdict, kind of show their work and hold them accountable for staying within the bounds of the evidence. And that finding a special benefit that exceeded that which was put on by the county was improper. The additor was the appropriate remedy. It was within the judge's discretion to do it. And offering the county a new trial sufficiently protected the county's right to a jury trial. And Sheridan, back up real quick. I want to say one more thing on that slide. So I talked about the Buckman case kind of quickly, and obviously I think if Rachel's on, she's like squirming because I didn't say everything I should have said or could have said about the case. But I do think it is interesting. I poured through many of the documents in the trial court as well as at the appellate level, and much was briefed in this case. There was a lot that the owners did to try to exclude special benefits or say that they were done improperly by the county in the case. And the courts just kind of appeared to ignore the arguments. There was a motion in limine filed that was just denied. And the issues were not taken up, though they were raised on appeal, they were not taken up by the panel. One of the interesting things in the Buckman case was the appraiser that was doing the work for Orange County could not say with specificity in his testimony what the special benefit was. And he was able to testify to a benefit, and he was able to say that it was for this property and there were special benefits, but he couldn't say of the $1.979 million, if some of it was general or some of it was special. And the courts didn't really grab onto that. We didn't see a ruling as to the special versus general, where in other cases in Florida, we have seen such rulings. Sheridan, if you'll click for me. Thanks. Okay, so some technicalities or some peculiarities about special benefits. They can only be used to offset severance damages. So they are not to reduce compensation for the part taken. If there are truly no severance damages, there can be no special benefit offset. One thing that we see appraisers for condemning authorities do is find no severance damages, have a section of the appraisal devoted to a special benefit, assign a value to it, but then kind of ignore that when they come to their ultimate conclusion of value. Obviously, thinking ahead to a property owner's putting on of their case, finding severance damages, this actually presents some form of rebuttal testimony and opinion to offset those severance damages. But that benefit that's found by the appraiser in the first cannot be considered unless there are severance damages to offset. The statute itself, as it presently reads today, limits who can claim an offset. And so that's just an important thing to think about as we're dealing with various entities that have the power of eminent domain, but may not be one of these few identified bodies. And they can only be considered in the condemnation of roads, canals, levees, or water control facilities. So parks, schools, those sorts of things, not going to be able to consider a special benefit in those types of cases. Oh, thanks. The specific attribution to the improvement or construction made or contemplated, another important consideration when you're an owner's attorney trying to battle the concept of special damages or special benefits, excuse me. And that the benefit must be directly and peculiarly related to the specific property. More than just general rising tide lifting all boats, it has to be the project affected this property in a unique way as compared to the neighborhood. The Limiatis case is cited there. The appraiser's testimony was stricken because he was not clear enough in his understanding of what the special benefit was that he found. And I think if you, I won't pull the case right now, but the gist of it is this appraiser, when asked about, well, was this a special benefit to the property? He said something to the effect of, I can't really tell you how it is better than the rest of the neighbors. I just know in my professional opinion that it is. And that was not enough for the court to say that it was truly a special benefit. And they struck his testimony as being incongruous or inconsistent with the law. Okay, so here's a hypothetical, and I'm going to breeze through this and wrap up here in a second. But the easiest hypothetical to think about where you could say that special benefits were possibly appropriate, it would be where a parcel is located on a 2-lane road. FDOT takes a part of that property for the construction of a new interstate highway. So the parcel gets bisected, new interchange put in. So now the road they were once on is now an exit for a major interstate. And where once the parcel was just like all its neighbors on a 2-lane road in the middle of nowhere, now it is one of those highly desirable interchange parcels that is different than its neighbors. The interchange is there. There's the convenience. There's potential changes in highest and best use, that sort of thing. All of that you would point to specific to the property and caused by the project. And that one is given as an example in several cases as kind of the simple version or the simple case. But it does get more complicated. And if we could click through to the next slide. What if it's a couple of parcels on a 2-lane road and that same interchange comes through, but instead of just bisecting one parcel, it's 4 parcels that already existed by separate owners. New interchange comes through and affects the 4 parcels. Well, is that benefit of being on the new intersection, is it still special? And I think the Levitt case addresses this and actually says there can be no question but that the land lying in all 4 quadrants of the limited access highway interchange facility, adjacent to the improvement and within close proximity to the entrances and exits of the interchange, is greatly enhanced in value over and above that enjoyed by more remotely located neighboring properties, which may or may not be on the highway and which may or may not enjoy a general appreciation in value in common with others in the general public. And it kind of says that it almost backs a little bit away from the idea of it being so specific that you have to say that it's different from all other properties. Well, those 4 properties may be similarly affected and improved, but as compared to the neighborhood, they enjoy a benefit that is different than the rest of the parcels in the area. The next concept here, medium breaks. I mean, obviously we all know police power, DOT or the condemning authority can do what they want within their existing right of way. And so I would say that medium breaks is an easy no, just because you get a medium break at your property and somebody next door doesn't, not a special benefit, not going to be allowed for enhancement. Similar, Jehoda thinking about increasing from 2 lanes to 4 lanes, bringing more traffic by, either a general benefit or not permissible under the case law to consider that. How about like a signalized intersection, or a traffic light? So a signalized intersection that affects just your parcel, or a traffic light then that serves more than one parcel, 2 owners, and the traffic light kind of helps traffic flow and affects the value there, or parcels behind an affected parcel on a signalized intersection. I think that's where you start getting into the murkier territory of, is this providing a compensable benefit? Is it enhancing the property in a way that is different than other properties on the project? And those are some difficult questions. You also get into, and I forget, I have a new version of this. So Sheridan, hit next and see if it says thank you. Yeah, some parting thoughts. That was it. But I do think there are some additional considerations. One of which is if the highest and best use argument, if you're going to say that now that the project is here, it's a higher and better use of the property is potential, and that affects the value. The value is increased as a result of that. Well, if that higher and better use as a result of the project is going to be used for special benefit offset testimony, you darn well better make sure that you're going through the same reasonably probable analysis that you would have gone through on the flip side, where if there's a rezoning needed or there's some other change in use that is required and some approval is necessary, then it better be buttoned up with the reasonably probable analysis as well. What are we all yelling about? It is a controversial topic. I don't know if it was so boring that nobody got their hackles raised, or maybe everybody had their antennas go up as I went through it. But I do think that there's a lot of interesting scenarios out there where special benefits are being used by condemning authorities to offset severance damages. And it will be interesting to see how the courts continue to shape this area of our practice moving forward as these cases go forward. And that is all I got. Thank you very much.
Brian, thank you. We have a few minutes if anybody wants to sling some questions at Brian, and we've got a few minutes time for questions if there are any. All right, there being no questions. Brian, thank you very much. Really enjoyed it. That's what happens when you get law review people going. And so, Brian, thank you so much. That was really a great presentation. I really appreciate it. Ryan, next up is Ryan Reese, Moore, Bowman, and Reese in Tampa. Ryan is going to talk about a fascinating question. Some of us, or most of us, have heard about special benefits, but I can tell you that most or many of us have not heard of what Ryan is going to be talking about. So Ryan, I'm going to turn it over to you and to talk about optional condominium termination.
Thanks, Blake. Everybody hear me all right? So I appreciate the opportunity to speak to everybody. And when Blake and I kicked this around, I think we both thought it would be interesting to present on a topic that really the committee, I hope, and I'm highly skeptical that anybody's really heard about. I gave this presentation before our local bar association group several years ago, and it may be redundant here for a handful of the locals here in Hillsborough, but for many of you, I'm guessing this is probably something you've never heard of. And while not directly related to the power of eminent domain, I thought this presentation would be very interesting to this committee because condominium termination as a statutory process impacts property rights in virtually the very same, pardon me, pardon me, I've got the allergy thing going on here in the summer, impacts property rights in virtually the very same manner as condemnation does, but without any of the constitutional or legal protections. And for some of us who do condominium work, we may be familiar with this topic. But again, for many of you, I'm guessing it's something that you've never heard of. And it's a topic that's near and dear to my heart as I spent the better part of 5 to 6 years litigating about it, trying to get the enabling statute stricken under both the takings and the due process clauses of our state constitution. So I think I can work the screen here. Good. So I want to start with the basics, and that is, what is condominium termination? Well, it's fairly simple. It's the process by which condominiums are converted to undivided ownership for purposes of redevelopment. And like all property, condominium buildings are not immune from the needs to redevelop. But to redevelop a condominium, you have to find a way to clear the title to all the individually owned units. And that can be a very tricky thing. Unit owners, as we all know, hold fee simple title to their units and a proportionate share in the condominium elements. And those are protected property interests you can't just unilaterally divest someone of. And so that's where the concept of condominium termination comes in. And it's a statutory process that's been codified in Florida's Condominium Act, Chapter 718 of the Florida statutes, since the 70s. I think it was enacted in 1976. And it's historically looked something like what I've brought up on the screen. And it basically is said that condominium property as a unique form of property ownership can be removed from the provisions of the Act by the consent of all unit owners and by the consent of all holders of recorded liens. So that was historically a unanimous approval required from all unit owners and their lien holders. And it was seen as the most equitable way to convert this property into undivided ownership. The terms of the building's sale to a private third-party developer, most likely, were worked out prior to a formal board vote and were recorded in the instrument that's called the Plan of Termination. And I'll get into that here in just a minute. But the important thing is that each unit owner knew ahead of time what their expected proceeds would be. And so it was a process that made sense and allowed condominiums to develop over time. So then fast forward to 2006, and we all know what was going on. We had the real estate boom. And so in 2006, developers lobbied the Florida legislature to make this process easier, the statutory process. And that meant lowering by statute the unit owner approval threshold to less than unanimous approval. And there was three principal reasons for that. And I call them the three H's. The first were hurricanes. In the late 90s and early 2000s, hurricanes had left smaller condominiums fractured and dilapidated and in need of repair. And this is especially in the southeast region of the state, in the Miami area. The second reason was for holdouts. Unwilling sellers, or what I call or refer to as dissenting unit owners, made obtaining or reaching the 100% approval threshold difficult, if not impossible, in a lot of these cases. And then the third H is higher profits. During the real estate boom, many smaller condominiums were located on prime real estate, and the land could be flipped and developed at much higher densities. And so developers during this period of time saw condo flipping as a very unique, profitable scheme. And so in 2006, make sure I've got it all brought up, Senate Bill 1556 was lobbied to the legislature. And really the legislative purpose behind it was to recognize that a lot of older condominiums in this state were trending toward economic waste and were in desperate need of redevelopment. And so the bill had a very narrow legislative purpose. And that was to, as you can see on the screen, revitalize condominiums that had fallen into disrepair due to negligent management or age, or had been rendered functionally obsolete due to deterioration or modern regulatory controls. And that legislative purpose becomes very important, what I'm about to talk about next. So Senate Bill 1556 created two new methods of condominium termination. The first, which is what I refer to as the economic waste impossibility provision. And basically provided, it allowed a building's condominium ownership to be terminated by a majority vote, 51% of the unit owners, when its continuance would constitute economic waste. And you can read those thresholds above. And that foot with the stated legislative purpose of the bill. However, the legislature, or the drafters, I should say, discreetly snuck in an entirely separate termination provision, and that's under subsection 3, called optional termination. And it allowed condominiums to be terminated for any purpose at any time, provided that 80% of the unit owners agree. And given our constitutional rights related to the protection of private property in this state, I think that's fairly significant. And I say snuck in again, and that's using my own language, because if you recall, optional termination is entirely untethered to that state of legislative purpose of ameliorating economic waste. And so just as a side point, the bill was actually originally vetoed by then Governor Bush out of concern for its impact on private property rights. And he drafted a veto letter that really had some interesting language in it. And he was afraid that this bill would cause, quote, unintended consequences by denying owners' rights without adequate due process safeguards, and that it was too far overreaching, and that it went too far in trying to allow the development of condos for economic purposes. And importantly, that the bill permit voluntary termination in virtually any circumstance, diminishing security in ownership of private property. And so Governor Bush directed the Department of Business and Professional Responsibility to now the Division of Condominiums, Timeshares, and Mobile Homes to conduct town hall meetings across the state and file a report with that would be reviewed by the Senate President, and the House Speaker on the public opinions toward this new optional termination process. And just as an aside, the state DBPR determined in its report that the legislature should not permit this process for the very same reasons that then Governor Bush had identified. Well, the very next year, Senate Bill 314 was lobbied, and it passed, despite the governor's warning, passed under a different political regime. And so this came despite warnings from I believe it was the Senate, I gotta go back here, pardon me, from the Senate Judiciary Committee, that the bill was substantially the same. There were no real substantive changes to the bill. And so the law took effect in 2007, and for the first time codified this optional termination process by supermajority rule. And so, some of us probably own condominiums, or nearly all of us know someone who does. And I'm willing to bet that if you surveyed those owners, less than 1% of them know that under current Florida law, their private property, their condominium unit, can now be taken away from them at any time for any reason, so long as 80% of the other unit owners in the building agree. And so there's been fallout, and that's why I find this issue so interesting, based on this new optional termination law. And so you may wonder why this is such a big deal. Well, here's why. Termination due to economic waste was rarely used. In optional termination, the other process was relied upon in nearly every circumstance because you didn't need a reason to come in and flip the building. And so during the boom, developers who wanted to flip these condos for profit were incentivized to come in, buy up a super majority of the building's units, but not all of the units. And this was even in newer buildings. This wasn't in just older, dilapidated condominiums. And so that one bulk owner, which is what the developers referred to in the statute, was legally empowered to divest the remaining 20% of individual unit owners against their will, with no stated reason. And so they no longer had to come in and negotiate with everybody and buy out the remaining dissenting unit owners. And the big implication is that last point. And as we'll see in a minute, the developers under this statutory scheme were able to take advantage of an appraisal process or evaluation process for the dissenting units that's really favorable. And you didn't have to negotiate and pay these dissenting owners fair market value or greater, because they didn't want to sell their properties. And so, why is this an issue that's related to this committee? Well, from a private property rights perspective, private condominium owners no longer had any certainty in how long they would possess title to their units, the terms of their condominium units disposition, and as we will eventually find out momentarily, how much they were going to be paid for their unit. And so I think that runs afoul of quite a few of our constitutional safeguards. And I'll touch upon some of those momentarily. So I call this regulated redevelopment of condominiums. And here's sort of how the process unfolds. And this is all set forth in 718.117 Florida statutes, and it sets forth all of the procedures. But in short, a developer, or what's called a bulk buyer under the statute, comes in and purchases 80% of a condominium's units. And a law firm's typically hired to draft a plan of termination. There may be folks on this call that have experience doing that. As the bulk buyer now monopolizes the condominium board, the termination plan or the termination proposal passes, and the 20% dissenting or minority owners have no say. The termination plan gets recorded in the public records, and that plan, which I'll outline here in a minute, details the procedures for winding down the affairs of the condominium. And of course, it serves as an encumbrance on a unit owner's title. Once that plan gets recorded, no market purchaser is going to come in and buy a condominium unit that's subject to an ongoing termination. The property is essentially unsellable to anyone other than this investor, developer, bulk buyer. And we'll see here in a minute that there's no statutory time frame for how long this process can take. And so the recorded plan of termination identifies or names a statutory termination trustee. And it's often an attorney, versed in real estate, who's hired and engaged by the developer to come in and oversee sort of the condominium winding down process. And this is where it gets really hairy, I think. The trustee is statutorily vested with all powers of the condominium board, including those in the declaration and the bylaws. And this is the really important provision. And it's set forth in subparagraph 14 of the Act. Upon recording of the termination plan, title to all of the individual units and the common elements automatically vests in the trustee by mere operation of law. And the trustee has a host of other powers, basically unfettered authority to sell, convey, or otherwise dispose of both those units and the undivided condominium asset without any input at all from the now former owners. And they can sue in the board or the association's name to oust those unwilling owners. And they're responsible for doing this, marketing and disposing of the condominium asset as efficiently as possible. And I ask everybody to remember this statutory provision. Upon recording of the plan, title vests in the trustee, and we'll visit that in a minute. So then comes the unit valuation. The termination trustee, as part of his duties, is responsible for selecting a, quote, independent appraiser to have the remaining, what I call dissenting owners' units valued. And the unit owners, importantly, have absolutely no say in this process. And so remember that this termination trustee is hired by the developer, hired by the bulk buyer. And so if he's hired by the bulk buyer and then he's the one tasked with engaging an independent appraiser, how independent can that appraiser really be? And that's some questions that we've raised in the litigation. And so what about the owners? Well, the owners are wholly removed from the process. They have no right under the statute to a competing appraisal. If they want one, they have to go hire an appraiser and at their own cost and expense. And so keep in mind the protections afforded in an eminent domain condominium. We'll compare them here in a minute. But by operation of law, and this is that same paragraph, subsection 14 of the statute, the now former owners are treated as mere beneficiaries to any proceeds realized from the sale of their units. And so I call that a conversion issue. I mean, you have taken an interest in real property and by statute converted it to one in personal property, their pro rata share in the proceeds. And this is same for all lien holders. And that brings up, I think, impairment of contract issues. The lien holder's interest, the lender's interest in any condominium units automatically gets converted to a share of the proceeds to whatever the mortgage has encumbered. And we'll revisit all these issues here in a minute. So the proceeds, upon having the dissenting units appraised, the termination trustee, just by certified mail, mails a notice to all the owners of their estimated distributions. It's a completely unilateral appraisal process. The unit owner, if he doesn't like the value placed on his unit, his exclusive remedy under the statutory formula is set forth in subsection 16. And there are 3 incredibly narrow criteria that a unit owner who doesn't like their appraised value can raise. First, you can challenge the fairness and reasonableness of the apportionment. And that's the statutory standard, quote, fairness and reasonableness. And there's no statutory criteria, and in fact, no case law that sets forth exactly what fairness and reasonableness means. And I call it illusory. I call it an illusory method of challenge because there's a provision in subsection 16, there's a statutory presumption that says, so long as the termination trustee follows the statute and hires a, quote, independent appraiser, the apportionment is presumed fair and reasonable. So it's an incredibly uphill battle facing that presumption. The unit owner can also challenge the idea, and this is going to be a huge issue here momentarily, that their first lien on the unit, their first mortgage, may or may not be satisfied by their share of the proceeds. And that seems fair, right? If you've got a mortgage encumbering the unit that you owe 200 grand on, and the value of the unit's $150,000, you ought to be able to challenge the apportionment as unfair because it's not going to compensate you for what you owe your lender. Well, the statute makes that relief sort of illusory as well, because it provides that the payment of the first to the first lien holder encumbering a unit may not exceed the share of the proceeds of the termination under the plan. So for all intents and purposes, whatever the appraised value is, they don't have to pay you more than that number just to satisfy your first lien on the unit. And so there's no guarantee that you're going to be paid enough proceeds to actually compensate what you'll owe your lender for this forced sale. And you can also challenge procedurally that the required vote for the termination was not obtained. And so to raise those challenges or to contest the fairness, you have to proceed by the statute through mandatory non-binding arbitration. And you have to do that at your loan cost and expense. And the unit owner who wishes to challenge the amount that they're going to be paid under this statute is met with a fee and cost shifting provision that serves to punish the unsuccessful unit owner. And so that alone is probably enough to deter most folks from challenging these things altogether, knowing that you're going to be footing the bill for the fees and costs of your defense of the case, plus potentially on the hook if you don't prevail for the fees and costs of the termination trustee in the arbitration proceeding. And that's something that Governor Bush identified in his veto letter, that's going to deter folks because there's going to be folks that most likely to be terminated are going to be those on fixed incomes or those who can ill afford the costs of any challenge. And we've done arbitration. We know that it's expensive, and there's procedural deadlines, and you really have to hire an attorney to take you through this process. But of course, that's going to be at your own cost and expense. And so only after exhausting that process can an owner actually proceed in circuit court. And so why does any of this matter for our purposes? Well, I think it's probably the most unfair law I have ever seen in Florida. It's a completely forced sale of your private property initiated by a private party with motivations that are purely private in nature. That alone is in disregard of many of the property rights principles we're familiar with as it relates to eminent domain. Some of the provisions which I've touched on just very quickly, you can see that all the cards are stacked against the unit owner. The presumptions in the statute that the apportionment's fair, the idea that the termination trustee hired by the developer gets to hire the appraiser, and that you have no right to a competing appraiser, and you're essentially forced to accept whatever value they place on your unit. The big issue, as we'll see by the case study that I'm going to tell you about here in just a second, is what happens when you are underwater on your loan. You've got a lender who's lent money on the unit, and now all of a sudden you come in and you're being terminated, and you're going to get an amount that's significantly less than what you owe your lender. And that's what we're going to talk about now with the case study that our firm handled. So my clients were Guy and Cheryl Neer, and they entered into a purchase agreement for a one-unit condominium unit in a Fort Myers condominium that was then unconstructed back in 2005. And it took 3 years to construct the building, which just happened to occur right as the recession was beginning to hit. And they ended up closing on their unit for $430,000. And they borrowed roughly $345,000 from an institutional lender to finance their purchase. Now, the recession hit, but they held on to the property and continued making all required payments under their mortgage. And the building became built out, but never operated at or near full capacity. And so 5 years later, having essentially been 5 years old, the condominium building, they received notice that a real estate investment company was going to come in and flip the building and flip the condominium building into likely rentals. And so this developer came in and they bought 227 of the 240 units in the building. And they offered my clients $180,000 for a unit that they purchased for $431,000. And so the 180 that they were offered, as you can see, was 250 some thousand less than what they paid for it, and $165,000 less than what they owed on to their lender. And so they of course rejected that offer and wisely hired legal counsel. And so the first plan of termination was recorded in the public records in 2013. And the NEARS challenged that plan on constitutional and procedural grounds in early 2014. And the plan was actually withdrawn. And a second plan was filed, Plan of Termination, was filed in its place later that April. And it was also challenged by the NEARS on constitutional and procedural grounds. And it was also challenged by other dissenting unit owners in the building. The second plan was eventually adjudicated void for procedural reasons 2 years later in 2016, and an appeal was taken by the termination trustee / developer. But at the end of the day, the second plan was ultimately withdrawn, and that mooted the ongoing appeal. And so a third plan was filed in late 2017, mind you, 4 years later from the original plan. And so we had to go back through the ADR process later that August, and the administrative law judge, because I raised a ton of constitutional issues, relinquished jurisdiction to the circuit court. And so we ended up challenging this third plan of termination on constitutional grounds in 2018. And we challenged it on numerous grounds, namely that this framework violated both facially and as applied the state due process clause, both substantively and procedurally, and important to our purposes herein, the takings clause. We also raised an impairment of contract claim and that statutory fairness and reasonableness claim under subsection 16. And so what I tried to do from the start was analogize this process to condemnation law. And our first hurdle was conveying this statutory scheme as quote unquote state action, so as to trigger all the protections that we're all familiar with. And everybody can see those on the screen. I don't think they bear any repeating. I know we're all familiar. So I tried to demonstrate that the law did not permit the power of forced appropriation to be delegated to a private third-party termination trustee. And I cited all of the statutory delegations of the eminent domain power to public entities. And we ultimately raised four principal arguments. First, that this optional termination process was essentially a de facto delegation of the condemnation power to a private third-party trustee. Second, that it operated in effect as a physical taking under Loretto. It ousted a unit owner of his domain and divested him of his title against his will. Third, that the optional termination process violated the public purpose requirements in the state constitution. It was initiated by a private party and was only for the benefit of economic redevelopment. And fourth, that it offended the full compensation requirement in just about every conceivable manner. And so I'll break these down just quickly. So the first issue, that it was essentially a de facto delegation of the condemnation power to a private third party. I tried to set forth in the briefs that when you look at it simply, it's really unit owner A being statutorily divested of his title by trustee B simply on account of developer C's financial means. And I'm unaware of any provision in the law that allows anything similar to that. Second, I pushed hard on Loretto, and we tried to liken this process to a physical taking. And everybody on this call is familiar with Loretto and the standards set forth. But I really pointed to the language that a physical occupation of private property could be by the government or others authorized by the government. And this seemed to be that very case. Our opponents argued, well, this isn't state action. Well, it was state action because they were relying upon a state statute to implement this process. And when you think about the protections afforded a condemnee under Loretto, consider that and contrast that with what happens under the plan of optional termination. Under subsection 11, the recording of the plan itself legally divests a unit owner of title. It says all rights in the unit and common elements automatically terminate on the date of the recording of the plan. The process physically ousts the unit owner from his domain against his will, and it eliminates statutorily all other interests in the property, leases, occupancy agreements, subleases, licenses, and any other contractual agreements related to the unit automatically, and converts that interest, that real property interest, into a personal property interest in the share of the termination proceeds. And so this, I would think, would be of huge interest to lenders. So third, I argued that the process was in complete derogation to the public purpose requirement in Article 10, Section 6A. I argued that you can't take property for a private purpose for the private benefit of a third party. And we cited all the cases, cited the cases where it was permissible, which everybody's familiar with. We cited the cases where it was not found permissible. Can't take property to establish a cohesive neighborhood. Can't take property to develop a more efficient use of the land. Can't take property for a shopping center addition. Can't take property for construction of private buildings. Can't take property for a shipyard that will be leased to a private corporation. To give property, to give somebody's condominium unit to a private developer simply because he has more money than the unit owners seems more egregious than any of these examples. And what was interesting is I pointed to the economic waste provision, the alternative method of termination, that did indeed have some kind of a public emphasis to it, at least from a due process perspective, that to take and do a forced redevelopment of a condominium to ameliorate economic waste or impossibility or frustration of continuance of the condominium type purposes, that did indeed further a public purpose. But this second optional termination provision under subparagraph 3, public circumstances or public purpose just simply wasn't part of the equation. It resulted in a forced expropriation of property for the sole sale, use, and financial gain of a private developer. Compare that with, the required showing of public purpose in eminent domain cases where strict compliance is required. And even the Kelo case, which I think is probably the most extreme example, determined that public purpose is satisfied only if the public uses or has a legal right to use the property. Here, I don't see how the public would ever have any right to use privately redeveloped condominium property. I think the biggest issue, and probably of most interest to our group, is how this process offends the full compensation requirement. I mean, we know the rules. Compensation is determined as if the condemnation were to never occur and the property owners voluntarily sold the property on the open market. And we know what all of the components of full compensation are. But I think it's worth bearing in mind that, as determined in the Smith and the Spafford case, compensation is a judicial function that cannot be performed by the legislature. And here, optional termination offends that in its entirety. It's got its own statutory valuation scheme where the termination trustee can go out and hire their own appraiser, and the unit owners have no say whatsoever. And that appraisal unilaterally sets the compensation that's going to be paid to the unit owners. The unit owners have no say in the value of their unit. You're essentially forced to accept the trustee's appraised value, or else challenge it in the law. That conflicts entirely with eminent domain law, where the unit owner can challenge the condemning authority's value, can testify to his own value, can hire experts to place him on equal footing to support his position, and you get a jury of 12 peers as the final arbiter. Here, with optional termination, the unit owner simply gets a letter and an appraisal and says, this is what we think your property's worth. You can accept it or take us to arbitration. There's no registry deposit that makes the condemnation funds available pre-challenge. And this is what's really egregious. The owner's essentially punished for challenging the process because the trustee, if you lose, the trustee's attorney's fees can come out of the overall distribution. And then, of course, the point about being resigned to strictly controlled arbitration proceedings with fee and cost shifting implications. So there's some great examples that I likened this process to. The best, I think, was the Store Cable case here in Florida, where the legislature had a statutory process, a statutory provision that authorized or that required rental property owners or leasees to submit to a physical invasion on their property of these cable television, of the